Partnership law. By the contract of partnership, two or more persons bind themselves to contribute money, property, or industry to a common fund with the intention of dividing the profits among themselves. Persons includes not only natural persons but also juridical persons. Bind themselves partners must be capable and competent, meaning, the following may not included: minors, emancipated minors, those under civil interdiction, insane persons and incompetent persons. Delectus personae, you can't join a partnership without the consent of all partners. Two kinds of partnership are general professional partnership or GPP and business partnership or BP. Note: professionals are not allowed to form corporations. General professional partnership or GPP are partnerships formed by persons for the sole purpose of exercising their common profession, no part of the income of which is derived from engaging in any trade or business. Business partnership or BP is an association of two or more persons to carry on as co-owners in a business for profit. Basic features of a business partnership. 1. Voluntary agreement. There must be a valid, purely voluntary agreement of parties to be partners, as no person may be compelled against his will to be a partner. 2. An association for profit. If the aim of the association is anything other than profit, it is certainly not a partnership. For this reason, associations for charity, civic or social purposes cannot be considered partnerships. Besides, the intention of partners must be to divide profits. 3. Contribution to a common fund. The partners must each contribute money, property or industry to a common fund as capital of the business. Real or effective credit, such as promissory note, or other evidence of indebtedness may be contributed as it is considered property. 4. Lawful purpose. As in other kinds of contract, the purpose of a partnership must be lawful and must be established for the common benefit or interest of the partners. Hence, no partnership can arise if the purpose is contrary to law, morals, good customs, public order or public policy. 5. Mutual agency of partners. A partner is the agent of his co-partners and the firm. The relationship of the partners is highly fiduciary in character. 6. Articles must not be kept secret. All partners are entitled to know the contents of the articles of partnership and each one must be given that opportunity equally with the others. 7. Separate judicial personality. A partnership organized under the Civil Code acquires a distinct legal personality from the partners and as such it can act as a legal unit. Kinds of partnership as to object. 1. Particular partnership, one existing where the parties have united to share the benefits of a single individual transaction or enterprise. 2. Universal partnership, one in which the partners jointly agree to contribute to the common fund of the partnership the whole of their property, of whatever character, and future, as well as present. Kinds of partnership as to liability. 1. General partnership. All partners are liable to the extent of their separate properties. 2. Limited partnership. Limited partners are liable only to the extent of their personal contributions. In a limited partnership, the law states that there shall be at least one general partner. Kinds of partnership as to legality of existence. 1. De jure partnership, one which has complied with all the legal requirements for its establishment. 2. De facto partnership, one which has failed to comply with all the legal requirements for its establishment. Kinds of partners. 1. General partner, is a member of general or limited partnership who is responsible to third persons with his separate property for his pro rata share of the partnership obligations after the partnership assets are exhausted. 2. Limited partner, is a member in a limited partnership who is not liable to third persons with his separate property for partnership obligations notwithstanding the exhaustion of the partnership assets. 3. Capitalist partner is a general or limited partner who contributes money or property to the common fund of the partnership. 4. Industrial partner is actually a general partner whose contribution to the common fund of the partnership is his industry or services, becomes the common property of all the partners, as well as all the profits which they may acquire therewith. 5. Managing partner is a general partner in a general or limited partnership who manages or administers the partnership business or property either by reason of agreement or pursuant of law. 6. Liquidating partner is a member of a partnership entrusted with the winding up of partnership affairs upon the dissolution of the partnership. 7. Ostensible partner is one whose name appears in the firm name, and who is known publicly as a partner. 8. Dormant partner is one who is merely passive in the firm, whether known or unknown, in contradiction to those who are active and conduct the business of the firm as principals. 9. Special partner is a member of limited partnership, who furnishes certain funds to the common stock, and whose liability extends no further than the fund furnished. A partner whose responsibility is restricted to the amount of his investment. 10. Nominal partner is a person who is not actually a partner but who, by his acts or omissions, is made liable, as a partner, to third persons for the obligations of the partnership. Property rights of a partner. 1. His rights in specific partnership property. 2. His interest in the partnership. 3. His right to participate in the management. Incident of rights in specific property. 1. Equal right to possess. Each partner has the right to possess specific partnership property for purposes equally with the others. But by agreement a partner alone may possess and use a specific partnership property for partnership purposes. 2. Property's right not assignable. A partner's right in specific partnership property is not assignable without the consent of his co-partners. The reason of the law why a partner cannot assign his dissolution and liquidation is because it is impossible to measure the partner's beneficial interest. 3. Not subject to attachment or execution. This has reference to beneficial ownership of a partner in specific partnership property as distinguished from the interest of a partner in the partnership which may be levied upon by a judgment creditor. 4. Not subject to legal support. The beneficial ownership of a partner in specific partnership property cannot be the subject or legal support since the latter obligation is personal to the partner. Rights of a partner. 1. Right of the partner to take part in the day-to-day management of the firm. 2. Right to be consulted and heard while taking any decision regarding the business. 3. Rights of access to books of accounts and call for the copy of the same. 4. Right to share the profits equally or as agreed upon by the partners. 5. Right to get interest on capital contributed by the partners to the firm. 6. Right to avail interest on advances paid by the partners for business purpose. 7. Right for indemnification in respect of payment or liabilities incurred for protecting the firm from losses. 8. Right to the use of partnership property exclusively for partnership business only, not himself. 9. Right as agent of the firm and implied authority to bind the firm for any act done in carrying the business. 10. Right to prevent admission of new partners or expulsion of existing partners. 11. Right to continue unless and otherwise he himself cease to become a partner. 12. Right to retire with the consent of other partners and according to the terms and conditions of deed. 13. Right of outgoing partner or legal heirs of deceased partner. Duties of a partner. 1. To carry on the business to the greatest common advantage. 2. To be just and faithful to each other. 3. To render true accounts. 4. To provide full information. 5. To attend diligently to his duties. 6. To work without remuneration. 7. To indemnify for a loss caused by fraud or willful neglect. 8. To hold and use partnership property exclusively for the firm. 9. To share losses. 10. To act within authority. 11. Duty to be liable jointly and severally. What is jointly and severally liable? Jointly and severally is a legal term that is used to describe a partnership or any other group of individuals in which each individual named shares responsibility equally. For example, if a judge rules that a number of people are jointly and severally liable for injuries suffered by a plaintiff, any one of those people may be pursued for payment of the full amount of the judgment. 12. Duty not to assign his interest. Dissolution and liquidation. Dissolution: the change in the relation of the partners caused by any partner ceasing to be associated in the carrying on of the business. Winding up: the process of settling business affairs after dissolution. Termination: the point in time after all the partnership affairs have been wound up. Rule on dissolution: on dissolution the partnership is not terminated but continues until the winding up of partnership affairs is completed. That would be all. This presentation is prepared by Miss Alvarez, Miss Bantog, Miss Barbosa, and Miss Bocarnau. Goodbye and thank you for listening.